If divorce is on your mind, stop. Because in Australia, the biggest mistake people make during separation is not in court. It happens in the first few weeks, quietly, before anyone realizes that the rules have already changed. Whether you think your separation is going to be amicable, high conflict, or whether it involves children, property, businesses, or family trusts, this could be the most important video you watch before you do anything else. I'm James Glissan, an Australian lawyer who explains how the legal system actually works before you're forced into it. And I've spent years watching good people permanently damage their parenting arrangements and financial outcomes in the first 30 days of breaking up, often without even knowing that they're doing it. And I'm not talking about the dramatic court battles, the ugly hearings. I'm talking about the small, well-intentioned decisions about money, living arrangements, messages to the other parent, or access to the children that quickly and quietly lock in your future long before a judge ever sees your name. Most people think divorce is a single legal event. And it's not. It's a process. And the most dangerous phase is the beginning, when emotions are high and legal consequences are invisible. So in this video, I'm going to show you how the family law system actually assesses behavior, risk, and credibility, and walk you through 3 common separation scenarios and the traps that come with them that I see over and over again: the amicable split, the combative breakup, and the complex asset separation. And if you understand these early, you don't just avoid mistakes, you keep control, and that alone can change the outcome. So first things first, let's clear up a huge misunderstanding about how divorce actually works in Australia. For the divorce itself, Australia is a no-fault system. The court doesn't investigate who caused the end of the marriage. But behaviour can still matter a great deal, especially where it affects children's safety or well-being, and in some cases where it impacts the financial pool. The legal ground for a divorce is an irretrievable breakdown of the marriage, and that's usually shown by 12 months separation. And in straightforward cases, once you file, the process often finalises within a few months, although it can take longer depending on issues like service or children under the age of 18. And this is important. Separation doesn't require any kind of formal document, not from the legal side. It can happen just by one person telling the other it's over and then acting on it. You can even be legally separated while living in the same house. But here's the part everyone misses. The divorce does not sort out your money or your kids. Those are entirely separate issues, and they are far more complex. From the moment you separate, your decisions start creating evidence and a practical status quo. The legal filing deadlines are different, but the practical consequences begin immediately. And this is why those early days are so critical. You're playing by family law rules from day one, whether you know it or not. The game has already started, and every move you make matters. Scenario 1, the amicable separation. So the first trap is hidden in the desire to be reasonable. And where possible, being reasonable is always a good thing. But even in an amicable separation where both people want to keep things calm, especially for their children, making kind, informal agreements without understanding the legal consequences can be disastrous. You have to remember, this is a legal system, not a fairness system. So here's the most common example. A person just trying to calm things down says, "Look, I'll move out for a little bit to give us space. I'll stay with my parents and just see the kids on the weekends for now." They think they're being helpful, they probably are, and they're taking a short-term hit for some peace. What you don't realise is that you've just created a status quo. So from the court's perspective, its main job is to ensure the children's best interests and stability continue. So if you show up in court months later and say, "I want the children 50% of the time," the first question the court is going to ask is, well, what's been happening up until now? And if the answer is that your kids have been living with your ex and that you've been seeing them on weekends and that they seem fine, courts are reluctant to change arrangements that appear to be working for the children. That doesn't mean early arrangements are automatically locked in. But the longer they run, the more influence they tend to have. And by the way, there is no automatic entitlement to 50-50 time. Parenting outcomes, like we said before, are determined by the court based on what it believes is in the best interests of the child. And that includes safety and practical realities. The same goes for finances. You might agree to let your ex stay in the house for now or accept a certain amount of money each week because you trust them. By doing so, you are informally setting a baseline, and that can be very hard to argue against later. So before you agree to any routine, you need a plan. And if you have kids, get a clear parenting schedule in writing from day one. An email confirming when you'll share care and how is powerful evidence. Remember, at this point, you're building a record and creating a status quo of shared care, which is a much stronger foundation to approach the court from. And while I know this is going to sound like a shameless plug, it is genuinely in your best interest to get a lawyer. Because any direct conversation, any email, any text you send is going to find its way into the other party's affidavit. Having a lawyer stops those messages from being direct, because it goes through a lawyer, and it prevents them from potentially being twisted into something they were never intended to be. Scenario 2, the combative separation. When a separation is filed with anger, mistrust, feelings of betrayal, and fears that you will miss valuable time with your children, people will make decisions based on fear and a desire to strike back. It's human nature. This is the combative separation trap, where your actions can severely damage your own case. For example, one person might start moving large sums of money from a joint account to their own. They tell themselves it's for security or to cover bills, but a court might see that as an attempt to hide or reduce the asset pool. And in some circumstances, that money can be treated as what's called notional property and effectively be added back into the separation. Under Australian family law, both you and your ex-partner have a duty of full and frank disclosure. That means you are both required to be completely honest about all of your assets, debts, and income. Hiding things or refusing to provide documents only makes you look bad in court, and it can lead to cost penalties and a whole host of other issues, even if the intention at the time wasn't to hide anything at all. Equally, we've had clients where the ex-partner was actively hiding assets and not the obvious ones. Things like undisclosed crypto wallets, overseas accounts, related party loans, or trusts that only show up when you know where to look. If you have any concerns about assets being hidden, and you think you or your partner may be looking at separation in the near future, the best time to speak to someone about it is before it's all out in the open. Because people tend to hide things before things are out in the open. In high conflict parenting situations, one partner may restrict the other's time with the children out of anger or fear, without pausing to consider the legal consequences. Those decisions are often made emotionally, not strategically. And the problem is that over time, this behavior creates a record that works against them. The court closely examines whether each parent is willing and able to support the children's relationship with the other parent. And patterns of obstruction can seriously undermine a parenting case. That said, there are situations where concerns about domestic violence or child safety are real, whether already disclosed or not. And in those cases, it is critical that any steps taken are clearly framed, documented, and explained as protective rather than punitive. When the court inevitably reviews what happened, it must be able to say that decisions were made to manage genuine risk, not to gain advantage or escalate conflict. So the solution, in a very general sense, is to act as if a judge is looking over your shoulder, because one day they might be. Do not take major unilateral actions with money, property, or children. The court divides assets by looking at contributions, future needs, and what is fair and equitable. It does not reward combative behavior. The court determines parenting orders based on the best interests of the child or children, not the emotions or grievances of the parents. Why family court feels so different to criminal court. Now, here is something that shocks a lot of people the first time they encounter it. The rules of evidence that apply in criminal courts do not apply in the family court in the same way. In criminal proceedings, evidence is tightly controlled. There are strict rules about hearsay, relevance, admissibility, and proof beyond reasonable doubt. Police have to meet high thresholds, and improperly obtained or unreliable evidence can be excluded entirely. Family law is more flexible. In parenting and property matters, the court is not trying to decide guilt or innocence. Its job is to assess risk, patterns of behavior, and what arrangements are in the best interests of the children. Because of that, the court has a far broader discretion in terms of the material it can look at. That means things like text messages, emails, screenshots, medical records, school notes, affidavits repeating what someone else allegedly said, and even allegations that have never been tested in a criminal court can all find their way before a family law judge. Now, it doesn't mean that anything goes. Judges are still careful, experienced, and skeptical, but it does mean that the material that would never survive in a criminal trial can still influence family law decisions, particularly around parenting. And this is why people get caught out, because they think, well, there were no charges, or the police didn't proceed, or it was never proven. Then they get blindsided, because the family court can still take those allegations into account. But this cuts both ways. If you act impulsively, or send angry messages, or make exaggerated claims, or escalate matters emotionally, that material doesn't just disappear because it wouldn't meet a criminal evidentiary standard. It can still shape how the court views you as a parent. The practical takeaway is this: family law is not about winning an argument. It is about managing risk and credibility over time. Every message you send, every allegation that you make, and every step you take should be made with the understanding that it may later be read by a judge without the protective filters people expect from criminal law. If you understand this early, you stop reacting emotionally. That's a good start. And then you start acting deliberately. And that alone changes the trajectory of a case. So we have covered the traps in amicable separations and combative separations. But what if your situation involves a business, family trust, or complex investments? Scenario 3, the complex asset separation. And this brings us to our third trap, which often affects high net worth couples. They assume that assets held in complex structures like companies or family trusts are safe from a family law claim. That's not necessarily true. The family court has very broad powers to look straight through the legal paperwork. What the court cares about is the reality of control and benefit. If a trust or a company was used to pay for the family's lifestyle, let's say funding holidays or school fees, cars, or just daily bills, it's possible that the court will view it as a financial resource or even property of the marriage, no matter whose name is on the paperwork. The bottom line is this: if your lifestyle was paid for by more than just a regular salary, you need an expert and you need advice to understand how that value is capable of being tracked and divided. Please don't make an assumption based on legal ownership alone. The court's reach is long, and it focuses on the financial reality. So, wrapping up, the 3 hidden traps that can define your future are well-meaning mistakes of an amicable separation, the reactive and damaging moves in a combative separation, and believing assets are untouchable in a complex financial separation. Navigating separation is one of the most stressful things anybody can go through, especially where there are children involved. But you don't have to be a passive victim. The decisions you make in the first few weeks aren't about winning a fight. They're about setting a foundation for a stable and secure future, both for you and your children. By understanding the system and avoiding these traps, you shift from reacting out of fear and emotion to planning with purpose. That's a big and important shift. And remember, the goal is to come out of this with a fair outcome that lets you rebuild. It's hard, but a different future doesn't have to mean a worse one. If you're facing this uncertainty and you need clarity on your own situation, my firm does these matters, and we can help you map out these critical first steps. You don't have to. This is for your benefit. This video is just to assist. But you can find a link if you are looking for representation in the description below. Subscribe for more practical advice to help you on how to navigate the Australian legal system.